I want to get into this question first. We had a Facebook user comment, Miriam Huther, say, "Where is Crystal? Can either one get a lighter sentence if they admit where she is?" Either one being Steve or Joey Lawson?
Not going to happen. I mean, there's legally a mechanism to where an attorney would file, or really it had to be the prosecutor would have to file and agree to do what's called a 6002 to alter, amend, or vacate a conviction in exchange for some sort of information like that. But that's not going to happen. They're not going to get a lighter, even if they said, "Hey, we'll tell you today where the body is." The prosecutor is not going to recommend a lighter sentence. It's just not going to happen.
So that mechanism that you were talking about, is that sort of like a plea deal?
It's not a plea deal. It's more of it's kind of like a last-ditch effort type of thing. It's something that's built into the rules of criminal procedure and civil procedure that allows a judgment later to be altered, amended, or vacated. For instance, it's happened in cases to where someone's convicted and then DNA comes back later. From old cases, they didn't have DNA, and they do test and they realize, oh my gosh, this person's innocent. They file that motion. Things of that nature. I filed it one time on a case where we had new evidence come to light about 5 years later. It's very, 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 very uncommon. I mean, 0.00001%. It's probably filed a few times a year in the entire state of Kentucky over several thousand criminal cases. So it's possible, but 99.99% would not happen even if they knew where the body was and were willing to say.
So there's not a world in which it would exist. Joseph Lawson tells prosecutors, I'm going to out Brooks Houck for, let's say, shave off 15 years.
Again, it's possible to happen. It's possible to happen prior to the sentencing, because remember, they have been found guilty and the jury has recommended a sentence, but they technically haven't been sentenced yet. So that's a separate thing in Kentucky. Being found guilty and being actually sentenced by the court are two separate things. So once they are sentenced, they are convicted. That could happen before sentencing, but again, I would say it's highly, highly unlikely at this point.
Do you think that the judge will take the sentencing recommendation and give Brooks life and give Joseph 25 total?
Absolutely. I think, again, there's no world where Judge Sims doesn't sentence according to the jury verdict. There have been times I've had, I know one, maybe two cases, I'm trying to think of the second one, I think I've had it twice, to where a jury recommended a sentence and the judge deviated by like a year or deviated by months or something like that based on the facts of the case. And usually it was because there was other mitigating stuff that wasn't apparent to the jury at the time. That being said, that's not going to happen here. I think that would be highly improbable. It's not you're better off buying a lottery ticket than to think Judge Sims is going to go below the recommended sentence here. Now with Joseph Lawson, most likely they would just serve him out. He wouldn't have that many more years to go. Brooks Houck, they could have reconsider him in 6 months after that if they didn't. Year, 2 years, 10 years, they could do, it's called a flop. So if they don't parole you out, you get what's called flopped. That's kind of the street term for it. And that means they give you another parole date months, years down the line. Or they could say no and deny it and, review the case in 10 or 20 years later. He could be an old man before he gets out, or he never may see light of day again on the street.
And what is a life sentence in Kentucky?
So a life sentence, there's different ways that there's what we call life, baby life. Those are just terms that are used. And there's life without parole. So there's what Brooks Houck got, which is a life sentence, which means he hits a parole board at 20 years. Now, if this was a capital case, what I mean by that, a capital murder case where there were aggravators such as a rape, a robbery, to where they would do individual jury questioning beforehand, essentially a death penalty case, okay? That's not entirely accurate, but it gets the point across to what I'm saying here is that you have life, and then if it was like a capital case with aggravators, you would have life without for 25 years, which means he wouldn't hit the parole board for 25 years, and then you have life without parole, which is complete, never can be paroled. He's got the least of the three here, which is just life, which means he hits the board at 20 years. So you got 20 years hit the board, 25 years, and then never getting out. His is a 20-year. But again, the parole board has no obligation to let him out. I mean, he could be 80 years old sitting in prison and they could say, nope, this crime was heinous. We are not letting you out. And we'd be, 40 years from now, and I could still say, nope, it's not enough.
So I have a list of questions here. We asked Facebook users to comment their unanswered questions about not only the case of Crystal Rogers, but also some of those unsolved murders around Bardstown. We got hundreds of comments, and one theme that I kept seeing over and over again is this mention of it being potentially a Houck family affair. Randy Gray saying, what evidence do they have for Nick and his mother? Do they have anything on the girlfriend of Brooks, who's Crystal Maupin? Again, she was present in the courtroom but never mentioned throughout any of the testimony. Is there anyone else they may look at? User Michelle Ingram said, how quickly could we see additional charges and arrests? What are those charges expected to be, and what are the sentences for those possible charges?
So everybody has to understand that, first of all, we have no more evidence or discovery than what's been presented in court, and meaning you, me, the media, other attorneys. Now, we do know there were over, I believe, 200 plus hours of video and audio in the discovery, which again is the evidence, and there were over 200,000, 300,000 pages of documents. We don't have access to that, and a lot of that, even in that stuff, has been redacted. Names have been redacted out, even for the attorneys that do have it. I've never seen it. I don't have access to it. I believe there's a protective order from the court which says, hey, only the attorneys and their clients are allowed to look at this. No one else is allowed to, including the media or anybody else. So that being said, we don't know what's in there. We have to go based on what we've heard in court. And what we did hear in court are a few things. Number one, we heard Shane Young say from the beginning, and right in Stephen Lawson's trial, that Rosemary and Nick Houck are unindicted co-conspirators. Number two, there was a recording played, I know the jury listened to, where Rosemary Houck, it was inadvertent, the recorder was recording her and Brooks Houck, and she mentioned something about, is the blanket still in the car? And Brooks Houck responded with, don't worry about the blanket, I took care of it, or something of that nature. So, which it's believed that had to do with Crystal Rogers and getting rid of stuff within, I think, their vehicle or her car. Number three, we heard early on, and we're talking a year and a half ago, at a bond hearing, if you'll recall, that Shane Young said they purchased a firearm from Nick Houck that they believe was used to kill Tommy Ballard. And that's a big deal, too. I think that's really the one big piece of evidence that we never heard in court, but we heard him say at a bond hearing that I am curious about, and curious what that will lead to. Certainly, it's hard to say what they would be charged with. It could be conspiracy to commit murder. We don't know. But the problem is they have to go based on the evidence they have. And we just don't know yet what evidence they do have. I would say if they get charged, it would be within the next 6 months to a year. Could be sooner, could be later. But certainly the prosecution's eye is on them. The question is, do they have enough evidence to proceed, to go to the grand jury, present it, and have a case they believe they could later win at trial?
6 months to a year, that's significant. That's the first time I've heard maybe even, your analysis on a potential timeline. I mean, we had one Facebook user say, it's been said publicly multiple times now, it gives us hope that it's coming soon. You think Bardstown residents can hold on to that hope?
I'd say it's not out of the realm of possibilities, certainly. And I would just say 6 months to a year. They just finished a trial. I think the attorneys that were involved, and that goes for all the attorneys, have to be utterly exhausted. I would say, they need some time to focus now. If they're going to shift gears, the prosecutors and the investigators, and consider indicting the other members of the Houck family, certainly they would have to shift the gears and the focus on the investigations there, because I think Brooks Houck has been the main focus of the investigation throughout this. So for them to kind of switch gears, they may have to pull other phone records. We don't know about Rosemary Houck's phone records, right? We don't know about Nick Houck's phone records, and I'm talking about GPS cell tower records, things like that. We know about Nick Houck's phone being off July 3rd and 4th, but we don't know about other things that exist that could tie them potentially to this. A lot of missing facts here from our perspective, because we just haven't been able to see it.
Right. Those phone records, of course, being one of the main pillars
Absolutely.
of the circumstantial case. I see. And yesterday, when we saw Bardstown come out in celebration with a parade because of this guilty verdict here, the main message was it's not over yet. We saw a big sign, it's not over yet. It's not over yet, but their prayers were answered for now, sort of pointing to those unsolved cases of Tommy Ballard, Jason Ellis, the Netherlands. I want to get your opinion if you think they're related to these cases or not, but another big story. One Facebook user, Donna Farnsley Miller Stinson, saying, not a question, but a statement. I really think that other family members were involved with Jason and Tommy. Ruth Adkins asking, when are they going to solve what happened to Officer Ellis? I mean, now that everyone is convicted, both the Lawsons and Brooks Houck, could we get the full story on what's happening in Bardstown?
It's hard to say because I think people forget that this was a tough case for the prosecution. Okay, and think about this. If this was such a hard case to prove, now they did prove it, they did a good job, and they got the maximum sentence here. But don't forget the amount of man hours that went into this case. And I'm talking about starting 10 years ago up through, really weeks before they're about to present the case to a jury. People have worked thousands and thousands of hours on this, and the question is, are those resources going to be available to switch focus? Because it's not as simple as saying, okay, we think you're involved too, we're just going to charge you. It's not that simple. They had to go into court and prove a very difficult case without a body, without a murder weapon, without a real strong motive, without knowing the specific facts of what happened. And they did a great job and they won, but I think people, now that they won and that Brooks Houck was convicted, people forget the difficulty of getting it there and the amount of risk that was involved. He could have easily walked out the door because they didn't have those things that, remember, a lot of people in that jury panel, when they were questioning him, said, absolutely not, I got to have a body. I cannot convict without having a body. And so, I think it's important not to forget that they still have to have evidence to go forward on Rosemary Houck, Nick Houck, or anybody else that, there may be other people we don't know about that are in that discovery or in part of this investigation that we've never heard about, because we heard facts we never even knew about, like Charlie Girdley with the hogs and the skid steer. We never heard that at all. For years, no one knew about that. And then he testified, and that was the first time we really heard about that. So we're not sure what's out there. And so I'd say it's possible. There may be something coming, but it is going to be driven 100% by the evidence and proof they have and their feeling of whether or not they think they can get a conviction.
Well, I think that speaks to this next question that a Facebook user asked. Tony Brown Goodman asking, well, why did it take 10 years? Because it's difficult to prove?
Difficult to prove. And this was a case, I talked to family members over the weekend, and some of them said, I just don't think, I know he did it, but I don't think they're going to be able to prove their case to a jury. I can't believe they took a shot at this. They should have waited till they had more evidence. And a lot of people, if a lot of the viewers remember, I was a kid at the time, but the case of Mel Ignato, it was a horrible murder. A young lady was killed and murdered, and he walked because the investigation was rushed. And eventually what happened was pictures were discovered in his home later after he was found not guilty, and so they couldn't try him again for the murder because of double jeopardy. And so, a lot of the family members I spoke to were frustrated and said, I just don't feel like they have enough evidence. They should have waited. So, this was a case, though, that they eventually had to take a chance on. But, it did take 10 years because I think at some point they kept looking and looking and looking and hoping they could find that smoking gun. And eventually they said, okay, we have to take a chance here. Win or lose, we have to take a shot. We feel like we have a shot, and certainly it worked out for them, at this point, luckily.
My last question for you, looking towards the future, Kathleen Faraday says, do you think they will appeal?
Absolutely. A couple things are going to come. There 100% before sentencing will be a motion for a new trial. Alexandra, I'm telling you, it's coming. It's going to be long. It's going to be lengthy. It's going to be contentious. It's going to be it's going to be red and your jaw's going to drop. I just expect it, and I think it will be a big fight within court. Secondly, appeals will be filed. That comes after the sentencing. Because remember, right now, The judge has just been given a recommendation. So they found them guilty, but technically they haven't been convicted yet. You have to be sentenced in the state of Kentucky. So what's going to happen is they will file those motions for new trial. Probably going to be a lengthy hearing on those. Will be very contentious. They'll tell the judge all the things they believe he did wrong during the trial. And then I assume the judge will deny that. Again, I don't have a crystal ball, but usually, you're asking the judge to second guess himself or herself. They're going to say, no, I know I made the right rulings. I was prepared. And then they will get sentenced. After that, they have 30 days to file a notice of appeal. So that would come sometime in late September, and they will file that. And I would expect this is the kind of case that will be briefed heavily from both sides. They will file very long briefs pointing out a lot of issues in the trial. I will tell the viewers, I think the one issue I expect them to focus on the most, with Brooks House specifically, is going to be that third murder instruction. Because remember, they didn't find him guilty of intentional murder. They didn't find him guilty of complicity. They found him guilty as a principal, actor, or a
accomplice.
Or accomplice, yeah, principal or accomplice. And as I've said on air, I've tried dozens of homicides. I've never had that in a case. I've never seen that jury instruction before. It was nothing that I've talked to several other lawyers. I mean, about everybody in the building I work in are criminal lawyers, and they've all said the same thing. I've never seen that instruction in my life. So, you have to understand, on appeals, 50% of cases that actually get overturned are from jury instructions, give or take. And that's an approximation, but it's about 50%. If you look at all the ones that actually get overturned, which is rare in the first place for a conviction to get overturned, but when it happens, about half of those are based on improper jury instructions. And so people have to understand, I had an appeal take 5 years before the Supreme Court ruled. So, it went on and on and on and on and on, and sat there for a very long time. And, this could go on for a long time, and it could get affirmed, okay? At that point, they'll file what's called a habeas corpus appeal to the federal court. I would not say that's any chance of that winning, but again, I'm not going to judgment call, but at low probability. But let's say that 4 or 5 years from now, 3 years from now, whatever it is, Supreme Court hears this case and they overturn it. Guess what happens? We go back to square one. Even if one part of that jury instruction was wrong and it didn't seem like it was a big deal, Supreme Court often will disagree and make it a big deal. Now, I'm not saying that's going to happen, but it's not out of the realm of possibilities. Not necessarily probable, but possible. And that's something everybody needs to understand going forward.
Interesting, because of course the defense, they're objecting to jury instruction number 4, it being ranked, A, B, C, with intentional murder, complicity, and then that principal or accomplice. Interesting that could potentially come up in the future. Again, and it's just, I think it's why it would make me nervous seeing it. It's just not something we're used to seeing every day. It's not something that we've all had that's went up to the Court of Appeals, to the Supreme Court, and they've affirmed and said that instruction's okay. And so that's the only one that really sat uneasy with me that I saw over the course of this case, that I thought, wow, they may have an issue with that. And ironically, that's the one they convicted him of. Gotcha. You've been so plugged into this, appearing on WHAS nightly for our specials and on our newscast. I'm sure you've gotten questions from friends, family, colleagues. Anything else that stands out to you that you want to address, questions that have come up over time that you think is important for the public to know? I think the public's frustrated it took 10 years, but I do want the public to understand this was a hard case for the prosecution. You had Jim Lisowski if there was anything such as a 10th degree black belt in prosecution, it's Jim Lisowski. I think he's got 41 years of prosecutorial experience, and he's still going. The guy is a machine. I mean, I tried a double homicide with him, and we won several years ago. Was a great mentor to me. I've tried cases against Shane Young. Shane you're not going to outwork him. But people need to understand, I get the frustration with why did it take 10 years? But this was a situation to where they got to a point and they said, it's not getting any better. We have to take a shot. And I'm sure they had that discussion with Sherry Ballard. I don't know that, but I've had cold cases when I was a prosecutor to where I said, look, we can hold off and pray something comes up. It could, like in that Mel Ignato case, but it very well may not. And so,
And in the situations I've been in, you know, I've had, luckily was able to work with families who said, you know what, win or lose, we want you to take a shot and we're ready for you to do it. And so it's important that people see that, you know, they worked hard, these prosecutors worked hard, but it was a chance they took, and it happened to work out for them, luckily, but it was not an easy case by any stretch of the imagination.